My name is Gerald Kitty. Mimi ni wakili na pia I run a business. I'm an entrepreneur. So the reason as to why I'm very passionate about entrepreneurs is because I've been down that road. Like I know the challenges, napitia as entrepreneurs, and now like marrying it with the legal terrain, then it becomes very refreshing for me. So I run a company called MoBar. MoBar is an on-demand drinks delivery app. We have 4,000 downloads now, and we are supplying drinks to Nairobi on demand, 24/7. I started out a little bit differently. I went out to do piloting at some point. It didn't work out for me, so I came back and then I started doing accounts. At least accounts, yeah, I was going through, but I didn't like it. Then I went to law. So when I started doing law, I felt like this is where I belong. So I did my degree at the University of Nairobi, Kamaliza, and then I started out immediately after the degree. I thought I should just get into tech and figure out what opportunities are there. So I started out MoBar. So MoBar, we had challenges, kissing so many frogs, investor frogs, before we found the prince. And then now MoBar took off, like it had a solid takeoff. As an entrepreneur, your best advice is to approach a lawyer before you get into problems. And sometimes just in the sense of just getting this person who is your friend, who you can always be bouncing off legal concerns with. That way they'll be helping you out for free. At some point they might realize and tell you, hey, boss, let's come into an arrangement. But at that point it's cheaper. Once you get into a mess, then it becomes a lot more expensive. So engaging a lawyer before is always advisable. And there are so many lawyers. Of course, you might want to approach a lawyer who understands your business, can be empathetic about your business, so that they can, they give you solutions that are very pragmatic to what you're doing. The new Companies Act allows for a one-man company. So there's no excuses of saying, oh, Kitambo, you couldn't incorporate a company without having co-directors and co-shareholders. Yeah, two directors. Now you can run a company yourself. So there is no excuse. So if you're a startup that is looking at growing, that is looking at investing, getting investment, then you're better placed going for a company as an instrument, because then shareholders will have stock to get ownership from, and in return to be given shares. If you're looking at, your company in imeanza, it's not all that. You can look at having a sole proprietorship, but the problem with the sole proprietorship is if you screw up, then your debtors will come for your personal assets. So it doesn't have the liability cover per se, like you're a personal guarantee for the business you're running. Partnership is always good, like when you're having a business that will require some skills that you do not have, or some strengths that you do not have, then you get into some sort of partnership. But even then, they're also constant, because each one of you might end up being liable. So the limited liability partnership gives you that option of having partners, but then also with the cover of limited liability. So, and then it also has options of having a person, a natural person, and a company as a partner. So you can be an individual and a company partner in one instrument. The founders agreement then captures all the issues that you as founders are going to foresee, and always look at the worst case scenarios that you can find yourself in when you're drafting the agreement. But you can come up with a restricted stock agreement, like a restricted shares agreement, which staggers how the shares crystallize. So if you are with a partner, you want that partner to share in the vision and to stick in the business for a considerable amount of time until the business is at a certain level. You wouldn't want a partner to come in today, get shares tomorrow, ameenda amefanya kazi zake. Yes, you can have a restricted share agreement where you're saying your shares will be vesting over a period of time after certain milestones, such that then you don't have a situation where you're exposing yourself. And this is also relevant when you're getting an investor who says, I can pump in a lot of money, I can have all this sort of expertise, nini. But then some of them, it's all gab, and then when push comes to shove, they are nowhere to be seen. But you already had an agreement that gave them shares. So you see, that's exposing yourself. So to avoid that, have a restricted stock share agreement where you're saying, I'll give you 5% shares after you've achieved these milestones and after this duration of time. Then another 5%, so like that. By the time they get their full shares, they have done their full part of their promise. Any legal battle is always won even way before you start a business relationship with your clients. Like when you get a client or when you get a person who is to supply you with particular services, or an employee or any stakeholder in your business, it's at that point that you determine whether you're going to win a legal battle down the line or otherwise. So, and the first instrument is always a contract. There are all range of contracts in the startup space, and just for about anything. Whenever there is an agreement between you and someone else, ensure that it's captured in a contract. There are so many, as I said. I just want to touch on a few, which I think are very crucial for entrepreneurs. And number one, entrepreneurs are people who are offering solutions. So their idea is valuable in itself. So you might want to have non-disclosure agreements when you're having conversations with potential, whether it's investors because they have the muscle, they can take your idea and run away with it. But also non-disclosure agreements with your employees, because when they work with you, they interact with what you're doing, trade secrets, etc., etc. So you might want to have that. You might also want to have a contract, IP assignment agreement. Sometimes you bring in an employee into your organization, and then while he is in your organization, they get bulb moments about certain things that have piggybacked on whatever you're doing, but they are totally new, their own creation. So you'd also want to have ownership of that. So you have an intellectual property assignment agreement beforehand, telling them that if you come up with anything in the course of our biashara here, then that is our, unless it is totally unrelated to whatever we're doing. You might have to have, of course, shareholders agreement. That's agreement that says, like, it governs our relationship, our ownership, our profits, if we are partners or if you're founders. Founders agreement, the same thing. It captures your relationship along the journey in the partnership. Employment agreements. You're employing someone. You might want to have an agreement that stipulates their terms. And this is very important. Sometimes you draft employment agreements, but you exclude the statutory minimums. There are statutory minimums in the act that if you do not capture in the employment agreement, then they expose you. The employment agreement becomes null and void. So you need to know like what minimums the act requires, so that when you're crafting an employment agreement, you capture them. That's how a lawyer can help you with that. And also just knowing what the law requires, like maternity leave. If you have an employee who is paged, and you have to give them 3 months leave. Someone is sick, 7 days with a consecutive working duration of two months. Such things, you need to know them.